And we're live. It is October 24th, 2024, 4 o'clock p.m. Eastern Time, and this is Trump Trials and Tribulations. Yes, it is 2 weeks until Election Day, less than 2 weeks. Yes, the polls are super close. Yes, everybody else is being distracted from whatever they're normally talking about onto, you know, who's going to win, early votes. Is John Ralston and Nate Silver a sage or a fiend? Not here at Trump's Trials and Tribulations. We're doing none of that. We're talking about, you guessed it, Donald Trump's trials and tribulations. Please don't forget to submit your questions using the Q&A function and to say whether you'd prefer to have your questions read or to have yourself raptured on and read it yourself. We got a fair bit of interesting ground to cover today. Stuff that's not going to be covered anywhere else. And I want to start with two articles, one of which we have already published and one of which we have not yet already published, but is coming soon. And one of them is by Roger Parloff, joining us from the Scont studio. Hey, Roger.
Hi, how are you?
And the other is by the estimable Quinta Jurecic, who is joining us from the Endless Scream studio at the Brookings Institution. Hey, Quinta.
Hello.
Anna Bauer is not with us today because she is working on still a third piece that we're trying to get out that we will have more to say about later. Quinta, let's start with you. You have been working on a overview of where we are in the fake electors litigations and trials around the country. So bring us up to speed for those who do not remember. What states have pending fake electors cases? And then let's go through them individually and talk about them.
Thanks, Ben. So yeah, this is a piece I'm working on with a co-author, Adam George, who is one of our student contributors. Shout out to them. They do great work. This is a follow-up to a piece that the two of us wrote along with two other student contributors back in the spring. The title of which was How States Are Investigating and Prosecuting the Fake Electors scheme. And that was exactly what it sounds like. We kind of thought that, the federal prosecution of Trump is getting all this attention. Obviously, there is the Georgia Fulton County prosecution, which when we were writing in April, had not yet totally run aground. But that, there were a number of other prosecutions and investigations going on as well. People listening might recall that, there were 7 states where there were fake electoral certificates or alternate electoral certificates, according to the Trump campaign, prepared. And all of those states at this point have conducted some kind of investigation into criminal accountability for the people involved. To kind of bring things up to speed, I will start with, let me start with Georgia. I can't possibly fill in for Anna Bauer, but I'll just say I think listeners are at this point familiar of the state of play in Georgia. Everything is basically on hold. We did have a brief bit of news today in that the 3 Trump fake electors who were charged in the Georgia case, the 11th Circuit rejected their effort to remove the case to federal court on the grounds that as electors or as nominal electors, they were in some way federal officials. But again, there's a lot more going on than just in Georgia. So let me start then with the states where nothing is happening. That would be New Mexico and Pennsylvania. And nothing has been happening there again since we wrote in April. Those states are different than the others in that the electoral certificates that were prepared for the Trump electors had language in there that explicitly stated, I don't have the language in front of me, but the gist is essentially these are contingent certificates. They are only to be used if it is determined, by a court that Trump actually won this state. And the attorneys general of both Pennsylvania and New Mexico have said publicly that language essentially meant that there were not criminal statutes that applied to prosecuting those electors because it was set up as fully contingent.
It's basically not fraud, right?
Essentially, yes. In the other states, the electors
Note that
were...
people, when you engage in fraud, always label it as fraud. And then, it's not fraud, right?
Well, so I will say, I guess, can I swear? Is that a problem on a live stream?
Fuck yes.
Okay, so there's, I'm skipping ahead of myself a bit here, but we did get a bunch of new information from some of this litigation about internal deliberations within the Trump team about putting together these certificates. And there is an exchange between Kenneth Chesborough, the lawyer, sort of outside lawyer who was working on this, and Mike Roman, a Trump aide, where they're kind of talking about how should we word the language here? And there's a text message exchange where Chesborough says, Mike, I think the language at the start of the certificate should be changed in all the states. He's responding to concerns from Pennsylvania where the language was changed. Chesborough continues, let's look at the language carefully. Roman says, I don't. Then Chesborough offers to help with the drafting. And Roman says, no caps, no punctuation. Fuck these guys. So there was an option to change that wording. But so in these other states, there have been at this point criminal prosecutions that are moving forward. So I'll just go in the order of events. So in Michigan, in July 2023, Attorney General Dana Nessel announced felony charges against all of the Michigan fake electors, 16 of them, charged with conspiracy and forgery. That case is still going through pretrial proceedings. We're waiting on a state judge to determine if there's sufficient evidence to send the case to a jury trial. That has taken a while because there are, in fact, 16 defendants. The big news out of there, I think, came in the spring when came out during one of these preliminary hearings, according to the special agent from the Attorney General's office, that the state of Michigan considers Trump to be an unindicted co-conspirator, along with another number of individuals, including Rudy Giuliani, Mark Meadows, Kenneth Chesborough, and others. So then if you move to the Southwest, Nevada, we had a bit of a weird journey here. So Attorney General Aaron Ford, who is a Democrat, initially said that state laws did not cover the state elector scheme. He then rolled that back in September of that year. And in December of that year, just before the statute of limitations expired, there were charges that were announced against all of the fake electors from that state. That was moving forward until in June of this year, a state judge actually dismissed the case as having been brought in an improper venue. The reason is a little complicated, but the very short version is that the case was brought in Clark County, Nevada. That's where Las Vegas is located. And the fake electors essentially argued, we didn't meet in Clark County, we met in Carson City. The only connection to Clark County is that we mailed the electoral certificates through there. There's even a little bit of dispute about that. The state pointed out that, this is the state's alleging a conspiracy. The number of the individuals involved were in Clark County, according to the state, when this conspiracy was being planned, and that was enough for a venue, but the judge disagreed. So now this case is on appeal to the Nevada Supreme Court. The Attorney General has requested expedited consideration, but we have not seen any movement there yet. So we'll see what happens there. Then we have Arizona. The Arizona indictment here, that came down in April 2024, actually just after we finished writing our last piece. The Arizona indictment is a little bit more like the Georgia indictment in that it has a pretty wide aperture. The other fake electors cases are very narrowly focused on specifically what happened in that state. This case indicts 18 defendants, all 11 of the state's fake electors, along with 7 campaign aides and advisors to Trump. Trump is listed as an unindicted co-conspirator, which again is interesting. I think there are questions about why that might be. There is a court filing that's on the docket from the Arizona Attorney General's office that actually indicates that the grand jury wanted to indict Trump or was seriously considering it, and the Attorney General actually talked them out of it. We can talk about why that might be. But this case also has hit kind of a weird hiccup. I don't want to get into too much detail, but the very short version is that Arizona has an unusual law that allows criminal defendants to file anti-SLAPP motions, which an anti-SLAPP motion is typically something you would only see in a civil case. Essentially, trying to get your case dismissed on an expedited basis on the grounds that it's sort of harassing you for exercising your speech rights. I don't know of any states in which there is a criminal anti-SLAPP statute. Arizona passed this law in 2022. Everyone seems to be confused by this law, including defense counsel, the prosecution, and the judge, Bruce Cohen, who seemed pretty visibly frustrated with the vagueness of the statute during a hearing in August. So we're currently waiting for Judge Cohen's ruling on the defendant's motion to dismiss under this anti-SLAPP statute, which is different from a typical motion to dismiss. So we will see where things end up there.
And I assume, like other anti-SLAPP motions, it's a kind of expedited, you deal with this first. And by the way, if you're the defendant and you prevail on it, then you get all kinds of attorney's fees.
I'm not actually sure about the attorney's fees here. I would have to check that, and I don't want to get it wrong because it is a bit tangled. It is a little unclear what happens if the judge finds that the defense has met the standard under the anti-SLAPP law. At some points, defense counsel sort of suggested that all that this would really need, all that it would mean would be, an open hearing where they could air different kinds of evidence and have, the kind of public transparency that you would want rather than just getting rid of the case altogether. I think that defense counsel was kind of trying to play down just how radical this statute might be if you read the plain text of it. But there was an amicus brief from the 2 legislators who introduced the law in the first place in 2022 saying like, nope, doesn't matter if these individuals actually, should be found guilty of this charge. If it was motivated in any way by politics, you got to kick the case out. So we really, it is a total mystery what's happening here. And I say this, like I said, I think Judge Cohen was frustrated. Assistant Attorney General Nicholas Klingerman at one point during the hearing said, and I quote, "The statute is so poorly constructed that I am not intending to concede anything on it at this point." So truly just nobody knows which way is up here.
So is that our full landscape of cases?
There is one more in the great state of Wisconsin. So this case had a little bit of a long and winding road. Wisconsin initially, there did not appear to be an ongoing criminal investigation, but we got criminal charges announced in June 2024 against Chesborough, Roman, and Republican operative Jim Trupus, all of whom allegedly were involved in orchestrating the fake electors plot in Wisconsin. You'll note that the electors themselves have actually not been charged here, which is distinct from the other cases. And this case, I think really it's fair to say seems to draw from some civil litigation that was done by the organizations Law Forward and the Georgetown Institute for Constitutional Advocacy and Protection, which had sued the electors and Chesbrough and Roman and ended up with a settlement that barred the electors from serving as electors in any election in which Trump was a candidate, and under which Chesbrough and Trupus, not Chesbrough and Roman, and that Chesbrough and Trupus agreed to release a significant volume of information, including text messages, emails, all kinds of internal documentation that really gave a window into just how the fake elector scheme got started, actually, and how it was carried out in Wisconsin. And it's notable that the criminal charges cite to those documents. It seems like the attorney general was relying really heavily on that kind of tranche of material. Again, this is pretty tightly focused on what happened in the state specifically, rather than taking a sort of, wider aperture view as Arizona and Georgia did. But I think broadly, it does give a sort of unusually detailed look into the backroom, machinations, because the attorney general had access to all of these documents. As to what's happening in this case, it's not totally clear. So there was a criminal complaint that was released in June. The defendants were initially scheduled to appear in court this September, and now their appearance has been delayed until December, which is a pretty long time to go without an initial appearance in court after charges are filed. But we don't really know what's happening there. So I think that, as with so many of these cases, there's a lingering question mark.
Do you have any theories about it? Are there any tea leaves to read about what could cause such a delay in an initial appearance?
It's hard to, speculate responsibly. I will say, if you look at the dockets, it is notable that the docket for Jim Trupus, there appears to be a sealed filing of some sort on that, which is not present in the Chesbrough or Roman documents. But I mean, it's anyone's guess what that could contain. And beyond that is really sort of the rankest of speculation.
I will just say that I think this would be completely improper in federal proceedings to have an indictment and then no initial appearance for 6 months. How long has it been?
Yeah, it'll be 6 months.
Yeah, and so there's clearly something about Wisconsin criminal procedure about this that I don't understand, because I cannot discern a reason, like as a matter of federal court practice. I think this would be I can't think of a situation in which it would happen. Can you, Roger?
No, not unless there were talks toward a plea.
Right, but
Yeah.
that might affect one of them, maybe Trupus, but I'm not sure why the others wouldn't, or if you had 3 of them who were working toward a plea, you'd still want and have to have an initial appearance for the others,
yeah,
right?
no, absolutely, right.
So it's something quirky going on, and I don't want to speculate about what it is, just because I just don't know Wisconsin criminal procedure at all, let alone well enough to do that. But I will say it's clearly some kind of story behind that. Is that fair, Q?
I think so. I mean, the only thing that I would say is my understanding is that, and I am also not an expert in Wisconsin criminal procedure here. My understanding is that it is more common for the initial appearance to take longer, at least in Wisconsin state court. I don't know if that's longer as in 6 months longer. It did definitely catch my eye as someone who's more familiar with federal court proceedings.
All right. Turning to Roger. Roger, you also have been doing work, research and writing, and you have decided to weigh in on the case of one of the assassins or would-be assassins of President Trump. Um, Tell us about why you got interested in his case that just happens to be in South Florida in the very same court that Trump himself used to be facing charges in until those charges were dismissed. And of course, they're now at the 11th Circuit.
Yeah. Well, this has to do with Routh, of course, was assigned by lot, presumably, Judge Cannon as his judge. And so on October 17th, he moved to recuse Judge Cannon. And I think this put the DOJ in sort of a funny spot, because it was going to have to take a position on his motion to recuse. And it was a relatively thin motion, but it was based largely on obviously the Trump appointed Cannon, but beyond that, the unusual rulings that Cannon had made in other Trump cases, two other Trump cases, the civil case that Trump brought to try to, right after the Mar-a-Lago search, to try to prevent the prosecutors from viewing the fruits of the search. And that was the case where she, in September 2022, shockingly ordered a special master and said that the prosecutors couldn't, the special counsel's office couldn't examine the fruits of the search until the special master went through it first. That was stayed by a unanimous, or portion of it was stayed by a unanimous panel of the 11th Circuit, and then unanimously reversed in costed terms in December of 2022. That was the case where, that was the decision where Pryor said that to affirm what Chief Judge Pryor of the 11th Circuit said, to affirm what she'd done would be to violate bedrock separation of powers limitations, ... and would require radical reordering of our case law, limiting federal courts' involvement in criminal investigations. So there was this history that preceded the criminal case that grew out of that same investigation. And ever since she was assigned to the criminal investigation and to the criminal case, the indictment, the classified documents case, a lot of people have wondered, should the special counsel move to recuse her? And of course, he didn't. The story got more and more complicated. There were more instances of unusual orders and rulings and behavior. The Times reported, of course, that apparently after the case started and she was assigned to the classified documents case, two other judges had tried to talk her into declining jurisdiction, the chief judge of the Southern District of Florida, and a second judge who wasn't identified. She kept the case. And then finally, of course, she dismissed the case, which was shocking to some. She dismissed it in July, and then it was appealed. And we saw the special counsel's brief, and still he says nothing about seeking reassignment of the case, should even if he wins the appeal. So people wondered, and here finally DOJ was sort of being forced to take a position. Is there anything odd at this point between about having Judge Cannon sit on a case involving Trump? And the other things that he brings up is that that Routh brings up in his motion is that Trump has very lavishly praised Judge Cannon for her rulings, and the possibility which that if he becomes president, he could reward her in some way, like a promotion, possibly to the Supreme Court. So there were all those things. They in the context of Routh's case, they aren't necessarily that strong. But so anyway, the DOJ was going to have to take a position, and by taking a position, you sort of wonder, well, what they would do, because they don't want to. I don't imagine they would want to undercut the chances of reassignment in the Trump prosecution. But on the other hand, it's not a strong position, and the DOJ has a longstanding interest in preventing defendants from judge shopping.
Right. So I find this a little confusing, because it seems to me that let's hypothesize that Judge Cannon is grossly biased in favor of Trump. How does that change the way you behave toward a defendant, given that it's not like the other judges on that circuit are in that district are for murdering Trump, right? And so it's like, I'm not sure the bias does anything more than reinforce the law, which is, you're not allowed to murder people, you're anybody. And there's, by the way, special protections associated with being a president or a former president. So let's say she's biased in favor of Trump. It's not like the other position is neutral or favorable as to killing him. So I guess I don't quite understand what he alleges turns on her supposed bias.
Well, I think that in the end, it's not a very strong motion, but the idea is that there's an appearance of impropriety. He doesn't say there's any actual impartiality, but that the public could perceive in this case of historic importance that for somebody that owes her lifetime appointment to him and could see in him a chance to go higher, that she would have a visceral reaction to somebody that had tried to assassinate this very person that would cloud her judgment. I think that would be how it goes.
Gotcha.
The DOJ responded and opposed the motion. It backed Cannon. It was one of the shorter opposition motions briefs I've seen. It was 1.5 pages. It was 6 sentences actually, plus a string cite. So I think it was an attempt to do their duty here, to say and like I say, you have to have a high bar for recusal, and it's absolutely clear that the mere fact that a judge is appointed by the president who is a party is not sufficient in itself. But most of those precedents have been created in the context of a case where somebody is challenging a president's official acts, and then the case is before somebody that judge appointed. Here, it's an entirely personal thing. It's an emotional thing. It's an assassination attempt. It might be Routh suggests it might be the only time in history when a judge has sat on the case of a man who was accused of trying to murder the person that appointed her. So it's an interesting situation, but I do think that it's sufficiently distinguishable that even assuming reassignment comes up at the 11th Circuit as an issue, I doubt it will make much difference. Reassignment, the special counsel has not asked for reassignment, but two amici have. So it's sort of in front of them. And one can imagine during oral argument that some judge might ask, does the special counsel take any position? And I assume they won't, because they haven't. But I also assume that this very brief opposition by the DOJ will be brought up by Trump as showing that they even DOJ thinks
that she's a great judge, one of the best. She's brilliant, I think was what Trump just said about her. What is the basis for the 6-sentence opposition? I mean, is there a substantive defense of her, or is there merely there's a high bar for recusal and reassignment? What is DOJ arguing here?
It's very 30,000 feet. It's high bar, and you haven't met it. There's nothing specific. And of course, in his case, it's a lot of references to the other case. Nothing, she hasn't done anything peculiar in his case. And yeah, it's that. It's also, he brought up some things, there's the wording is really 455A, I think, 28 USC, the statute relating to recusals. It's something like a reasonable appearance. A reasonable person might find, I don't have it in front of me, an appearance of impartiality. And it has to be a reasonable person. And he was bringing up things like, well, all three of these cases involving Trump end up in front of Cannon. And so the public may think that that's non-random. Well, the clerk's office has told us it's random.
The clerk's office knows that. And by the way, the chances aren't even that small. There aren't very many judges.
I think we need a statistician to run the numbers
there aren't very many judges on that particular wheel.
Yeah. So and so you can't do that. You can't, disregard the facts and sort of use it has to be a highly informed third party looking at this objectively, and would that person think there was a reasonable appearance? And so I think that part of it was especially weak.
All right, so let's in other Eileen Cannon, I'm not sure if this is news or gossip, but Judge Cannon has shown up on an illustrious list, which is the list of possible attorneys general for a President Trump. What do we make of this list, and how, if at all, is it playing in this litigation?
Yeah, this was Catherine Falders of ABC News reported this on October 22nd, maybe, which was after the DOJ filed its filing and a day before Routh filed his reply, and Routh does include it in his reply. So it's, but, so it's all, it sort of supports his notion that she could get a promotion out of this. But it's sort of important to also say that she hasn't done, she
hasn't done anything.
Right. What Trump says about her, she can't control. What Trump, what's going on in Trump's campaign headquarters, allegedly, if it's true, she can't control. So, and it's also technically true that, it's technically true that whatever judge is presiding, over a Trump case, if he likes the ruling and he becomes president, he can put them on the Supreme Court. You know, you could replace Cannon with Middleton or somebody like that. And
Okay, but
yeah.
Roger, I wanna just
I mean, theoretically,
note a really massive thing that just happened here for the first time ever on Trump Trials and Tribulations. We have defended Judge Eileen Cannon 100% with no caveats.
well, for the caveats, please read my article.
Okay, so what are the caveats?
Well, I mean, I think there's a stronger case to be made in the United States versus Trump.
Right. So on the reassignment issue in the 11th Circuit, that's a more substantial issue. But should she be allowed to sit on the Routh case? Should she recuse? Sounds like DOJ is saying, no, she didn't do anything wrong here. And you're saying, right.
DOJ is saying she doesn't, certainly there's nothing in the law that requires her to, and they did oppose the motion. And I guess they say, if there's nothing that requires you to, you shouldn't. But, and yeah, I guess I'm saying I'm okay with, I'm actually okay with Cannon sitting on Routh's case.
I am too. I just think there are many issues that divide Americans. Murdering former presidents isn't one of them. If it's a pretty routine case, I'm fine with Judge Cannon handling this one. All right, here's something I'm not fine with, though, Roger. Also related to what would happen if Donald Trump became president. He says he would fire Jack Smith in 2 seconds. So what do we know about, first of all, my recollection, don't have them in front of me, of the special counsel regs, is that the president can't fire the special counsel, only the attorney general can. So what do we make of this statement? What do we know about it? And can Trump actually do it?
I think through the attorney general, he can actually do it. I don't think anyone questions that he can get an attorney general who will do it. That's not the same as dismissing a case. And I don't know exactly what happens in terms of the 11th Circuit case, who then continues to litigate that. I think but I think the appointment terms for Jack Smith did not have a high. Well, I shouldn't talk about that. I'm sure there's a way for him to fire.
No,
Jack Smith.
the way for him to fire him is exactly the way Richard Nixon fired Archibald Cox, which is to direct the attorney general to do it. The attorney general can either do it or resign and refuse and resign, at which point you have a Saturday Night Massacre like situation, except that Donald Trump would appoint as attorney general or acting attorney general the sort of person who would do it, whether it be Eileen Cannon or Jeff Clark.
There have been like regs that the attorney general will issue a sort of a regulation about governing the appointment, and that may say he can't fire him without cause. And I don't know what this one says, but even if that were the case, you can rescind the reg,
right,
and then fire him.
Yes,
so
and you can.
There are ways to do it.
You can also assert that there is cause.
Yeah.
And since it's essentially not litigatable, or at least not easily litigatable in the short term, there's no your assertion that there's cause becomes and by the way, if you direct Jack Smith to drop the case and he doesn't, defying a direct order probably is cause. So one way or another, you can get it done. I don't think you can get it done in 2 seconds.
No, and then the dropping of the case, the judge has a say in that. You need to get the judge's approval to drop the case, and that's a whole other can of worms. But again, it becomes extremely difficult once the DOJ is not pressing forward, to know how to even if Judge Chutkan say does not want to have agree to drop the case for no reason whatsoever, how that proceeds without the DOJ on her side anymore.
There's
All
one just quick note here. I think it's worth just flagging that we had all of these conversations during the Mueller investigation. Like, I vividly remember gaming out, okay, if Trump were to fire Mueller, how would that specifically work? What would happen with the case? Right. And on and on and on and on. So there's more than a little bit of deja vu happening here.
Deja vu all over again, as Yogi Berra would put it. All right, so let's do a rundown of our cases. Roger, bring us up to speed on the DC case.
Yeah. So you all know on October 18th, the redacted appendix was released. And it was very redacted, which was expected.
One might say that Jack Smith had his appendix out.
Thank you, Ben. And so it was about 1,900 pages, and about 1,200 of them were redacted. Before mentioning that, there was a last-minute effort by Trump to keep this under wraps, even though there wasn't a whole lot to keep under wraps. You remember he had asked for 10 days to seek a mandamus. After she ruled that she was going to release it, he asked for 10 days to consider litigation options. He took the 10 days, and at the end of the 10 days, he said, "Can I have another couple months?" And she said no. He wanted to file sort of a counter appendix, and he wanted them to come out together. So anyway, it came out. Oh, actually, and in the I told you so vein, she, if I have it, when she decided that she would release it, she told him, and this gets into our discussions about the 60-day rule last time we were here with Jack Goldsmith, and she said, if the court withheld information that the public otherwise had a right to access solely because of the potential political consequences of releasing it, that withholding could itself constitute or appear to be election interference. So that was the answer sort of to the 60-day rule in the context of an ongoing case. She's saying, either disclosing it might help one side, but withholding it might help the other side. There's no, there's no, we just need to go forward, and the constitutional presumptions here were in favor of disclosure, at least of this much information. And it was 4 volumes. The first volume was a lot of I would say generally, there's 2 things going on. Part of this is the proof that the defendant is guilty. Part of this is simply the proof that the defendant's acts were not official. So there is a lot of technical stuff. There's stuff about who paid for the Ellipse rally and things like that. So the first volume was mainly, I think it's 18 excerpts. Well, there's a tremendous amount. All of the grand jury testimony is sealed, so we don't know what is grand jury. Same with all of the FBI interviews. So like 302s, FBI 302s and things. So we don't know how many of those were in there. But there were 18 excerpts from January 6th interviews, January 6th committee interviews, the select committee. people like Bill Barr, Russ Bowers, Kellyanne Conway, Justin Clark, and so on and so on. There was volume 2 was tweets primarily. I think maybe all tweets, over the majority Trump's tweets and retweets. It would often include both the tweet and the extraction from his phone, showing that he originated the tweet. I assume that's the idea. I assume that's why that's there. There were also tweets from a few others, Chris Krebs, the head of the cybersecurity infrastructure security administration, or whatever the words mean, letters mean, and several other, Bernard Carrick and Christina Bobb and some others. Volume 3 was, it had the Mike Pence book excerpts. We assumed that Pence also testified, but these were book excerpts. I don't know. We don't know exactly what that's about. If she's, if they want to point out like this is already public and therefore, you know, we shouldn't even, is that an additional reason not to worry about it? Is this a reference to footnote 3 but there was no overt reference to footnote 3 of the immunity ruling. So we're not sure what that's about. There were transcripts of his ellipse speech and of the Dalton, Georgia speech 2 days earlier, all to very similar, showing that they were both campaign speeches, not presidential speeches. 3 of the Chesbrough memos and variants, the false elector packages themselves, you know, the false statements that we're duly elected and we're voting for Trump and duly appointed. Volume 4 is an Eastman memo about multiple versions about January 6th scenarios, Pence's handwritten notes of a meeting. I think, I don't know if it's January 4th or January 5th. I can't remember. And then there's a handwritten note from a January 5th meeting that might be Greg Jacobs, his lawyer. We're not sure. And then there's a lot about, in both volume 1 and volume 4, there's a fair amount about this effort, this last minute effort where Chesbrough was trying to deliver the false elector packages for Wisconsin and maybe Michigan too to Pence. And there's a lot of attention to that. There was, you know, they hadn't been mailed. Apparently, the archives hadn't received them, or the Senate, wherever it would go to get to Pence, it hadn't been delivered. So they were trying to hand deliver them. And I think this relates to the 1512C2 charge. You know, the 2 of the charges are corrupt obstruction of an official proceeding. That the Supreme Court has narrowed that statute, and now you have to prove an attempt to impair the availability or integrity of evidence. And the government's theory is primarily that, and the Supreme Court had said that creating false evidence does count. And so they are fitting this into the creating false evidence category, and saying they were trying to obstruct the proceeding by getting the false evidence before the proceeding. And so that was why so much attention to getting these to Pence.
All right. Let us turn to the New York case, which is quietly bubbling along, not producing a ruling on immunity or sentencing. Where are we with that, and has there been any action?
There has. On October 14th, Trump filed a brief in the Second Circuit. So what's happened here is, remember, the sentencing is now supposed to occur November 6th. The immunity ruling by Justice Merchan will be on November 12th. He'll decide whether the evidence that came in at trial violated the Supreme Court's immunity ruling. And if it didn't, we would then proceed to trial on November 16th, 4 days later. Trump filed an attempt to remove the case to federal court, which he had already done at the beginning of the trial. And this was his second attempt. And Judge Hellerstein gave him very short shrift. He dismissed it in 4 pages. And frankly, I don't think he gave it enough attention. But then Trump appealed to the Second Circuit. And I think what he wants is to prevent the sentencing from ever occurring on November 16th. And so he filed, and it's 99 pages. And it's got a lot in there, including a lot that you would consider more like appellate stuff. He rehearses, his recusal motions to Merchan that were rejected, and some other things are rehashed. But the core of it, which I think may be right, is that, once the Supreme Court decided that there were all of these new immunity rules to abide by, he's saying, I am entitled to get a federal court to decide these new federal rules. And I don't,
why do you think that's right? I mean, if it's a federal constitutional question that the Supreme Court takes seriously, they can address it on direct review if the New York Court of Appeals doesn't apply it. But look, if you indicted a foreign ambassador in New York State court for, murdering somebody with a hatchet, under, New York state law, and they pleaded diplomatic immunity, you wouldn't remove it to federal court because you would just treat the immunity in state court. So why is this any different?
Well, I don't know the law on the question you're asking. I'm a little surprised there isn't. I'm a little surprised if there isn't a removal statute for that situation. The federal removal statute is incredibly opaque to me.
Yeah, it's a total mess.
And so whether it does cover this or it doesn't cover this, I think it ought to cover this. But anyway, so I think it's a very messy thing. It's 99 pages, but it may not matter for this reason. On October 18th, the district attorney asked for 91 days to file a response brief. So that would take us to January 13th. And the next day, the Second Circuit said, fine. And so, so the sentencing is going to happen. If the immunity ruling, if Merchan finds that the immunity, the Supreme Court's immunity ruling was not violated, or that it was, if it was harmless error, he will proceed to sentencing, and this does not seem to be the thing that will stop it. And once they get past there, whether he still cares about a removal at that point,
it'll depend what the sentence is.
Yeah, I don't know.
All right. This is probably the last time we're going to talk about the New York case before the election, right? There's nothing else is happening.
No, that's right.
All right. So
can I make a quick point on that?
Please.
I think that the fact that nothing else was happening before the election is a good reminder of the influence of the Supreme Court's immunity decision here, right? There is no reason that this case should have been pushed back so late. But for the fact that the Supreme Court included this bizarre little section on immunity on evidentiary matters in
This case meaning the
the
New York case?
Yes. Like that is the only reason that this is happening right now, and the only reason why we don't have clarity on sentencing or on whether or not the conviction itself can stand. And I feel like we all know this, but it's worth just banging our fists on
actually,
the
I
table
want
about
to
it.
slightly disagree with you
Okay.
about this because as you all know, I have been a fierce defender of Justice Merchan, whom I think has done a very good job. But he decided to push this back until after the election, not issue his application of immunity ruling, and not do sentencing on what I think was supposed to be September 16th, I believe. He had set a schedule and then he moved it, not because of the Supreme Court. The Supreme Court had already ruled and he'd done his thing in light of it. But I think because of all this removal action that he wanted to give a chance to play out. So I think, like, my enthusiasm for the Supreme Court's ruling is, I assure you, under control. But I think in this case, this was that Justice Merchan got cold feet about acting before the election. What do you think, Roger?
Well, I'm not quite sure that's right, because it was the back and forth on the immunity briefing that led Merchan to repeatedly delay sentencing.
No. I mean, I don't think it's pushed off because he needed time. I think he pushed it off finally this far because he felt he didn't want people to think he was trying to affect the election. And I mean, that's how I remember it. He did have to push it off once, but not this far. And the only other thing I'd say is, I don't mind his ruling there because I get where he's coming from, but I just want to add that, of course, this was the aspect of it that even Justice Barrett would not go along with. This is the pure 5-4 aspect. The New York, that opinion has nothing to do with New York except for that's a 5-4 ruling, and that was the one where Barrett said, "I don't get this," and
it has an impact, for those who don't remember, on the New York case because of Hope Hicks's testimony, and specifically because of the, in retrospect, quite unfortunate manner in which Hope Hicks's testimony was used in closing argument. I think if it had been less dwelled upon in that close, there may have been an argument that it's harmless error, but that's a harder argument to make, given that it was presented to the jury as, this is the smoking gun. Hope Hicks burst into tears. All right.
You're just mad that the closing went on for so long, Ben.
I'm still mad about that. That was too damn memo to the New York DA's office. I know you're really proud of yourself about that close, but it was too damn long. All right, let's talk about the Georgia case. Before we get to the case, yes, Nathan Wade gave a deposition to the Jim Jordan committee, and we have a question about that, which we're going to do when we turn to questions. So we can leave it out of the Georgia case roundup, because we're going to treat it in the context of the question. Roger, what's going on in the mess that is Fulton County?
There's a slew of removal or activity relating to the removal actions and appeals out of Fulton County. So so Meadows, the briefing in the Meadows cert petition is completed at this point. It was completed 2 days ago, and that will go to conference on November 8th at the Supreme Court. So we might get a cert ruling either. I don't know if they ever do that Friday afternoon, or if that would be Monday morning or Tuesday morning. This is, remember, he was trying to remove his case. The federal district court said no. It went to the 11th Circuit, and the 11th Circuit said, shockingly, because nobody, not even Fani Willis, had thought this, the 11th Circuit decided that the removal statute only applies if you are still a federal officer, not if you're a former. 200 years we've had this law, and that was a real shocker. There's no ruling on it because everyone assumed it applied, even if you were a former. It also went on and said, even if it did apply, Meadows wasn't entitled. So both those issues are up, but obviously the first one, I think, is, I would be really surprised if they didn't take cert on that first issue. And then today, there were 2 more rulings. All of these are by, the lead ruling is by Pryor,
Judge
the
Pryor.
chief judge. And the 2/3 of the panel are the same in these others. Rosenbaum, the third guy, differs from the Meadows panel. So these were Jeff Clark, who, remember, was with DOJ, and Clark says, well, he too was not a federal officer anymore, so he rejects the petition solely on that ground and doesn't reach the rest. So that's based on Meadows. So if Meadows is overturned, there's going to be more delay. Rosenbaum, in a concurrence, goes on and says, you're not covered. Your job at the Environmental Protection Service, you were at DOJ, but your job was related to environmental spills and things like that. So your criminal acts had no relationship to your job. And then the third judge followed Pryor, said, yes, I'm bound by Meadows, the ruling about former federal officers, but I don't agree with it. And that's all he said. And then the second ruling involved 3 electors, contingent electors, David Schaefer, Sean Still, Kathy Latham. They were trying to give federal officers status. And again, Pryor said, well, even assuming you were a contingent elector and that's a federal officer, you're a former, and so you're not covered. Rosenbaum said, look, contingent electors don't exist in federal law. There's no such thing.
You're not a federal officer.
Yeah. And in fact, he said defendants were no more presidential electors simply because they give themselves the title than Martin Sheen was ever the president because he went by President Bartlett. See generally the West Wing. Then he goes on to say that, even lawful electors are not federal officers. So, but once again, it's only Rosenbaum because Grant too follows Meadows unwillingly. So if Meadows is overturned, I don't think any of these stand. So it's a bit of a mess.
Although some of them have alternative bases, right? There's no way the 11th Circuit is going to rule that a contingent elector is a federal officer for purposes of the removal statute. It's possible, I suppose, that they could rule that a former actual elector is a federal officer, although really what he is a state officer, but that's a different matter.
There's no way, but unfortunately they haven't. And so we
right,
would,
because
there
they
would
went
be
off on
additional,
this,
yeah,
they went off on this fracacta theory
yeah.
about formers. All right, we want to turn to audience questions, but before we do, we have a Roger Parloff special to end with today, which is, Roger's, one of his specialties is to spot the things percolating in Judge Carl Nichols's court that are going to creep up the appellate ladder and lose the whole way until the Supreme Court uses them to throw out very large numbers of not January 6th cases. And remember, Roger was writing about what became US v. Fisher probably like a year and a half before anybody else wrote anything about it. He's got another one. We've got a DC Circuit case. And just to add a sort of twofer element to this being a Roger Parloff special, it involves Roger's old friend, Cooey Griffin, who I believe is the only federal official who's actually been barred under the 14th Amendment, Section 3, from holding office in another set of cases that Roger was sort of the first person to cover. So all roads collide in this Roman road traffic circle of Roger Parloff. What's going on in the 2-1 DC Circuit ruling in the Cooey Griffin case?
Yeah, I do believe this is an issue that Carl Nichols, who was the only judge at the district court level that thought there was a problem with 1512C2, but I think he was the first to spot this issue as well. In fairness, other district judges then, this is a more evenly divided situation, but this is fundamentally, at a common sense level, crazy, but at a textualist level, apparently relatively convincing. And so 1752A is entering and remaining in a restricted zone. And so more than 90% of January 6th defendants were charged with this. It has some different forms, but more than 1,400 people out of, the more than 1,500 that have now been arrested. But restricted zone is then further defined, two sections below. And it can be several different things. One, it can be the White House. Two, it can be, two is the one that's always used in the January 6th case. It's something like a Secret Service protectee is or is expected to be there. And then C is something else, some sort of designated a special event. So the CB, the C2 section was the one that was always in these cases because Vice President Pence was expected to be there, temporarily be there. So the question is, knowingly enters and remains in a restricted zone. Restricted zone means, cordoned off, and other words like that, visibly restricted, and then finally, and has the Secret Service is expected to be a Secret Service protectee. So how far does the knowingly extend? Do you need to, up here, enter
Does
and
knowingly
remain.
modify every single clause, or
yeah.
does it merely knowingly does knowingly merely modify enter?
Exactly. And so, let's put on our thinking caps for a moment. How, it's relatively easy to prove that somebody knew that this was cordoned off. There were toppled bike rack barriers which were labeled keep out. There was a sound system in loop saying this is a restricted zone, keep out. There were fire alarms. There was wafting, CS, not CS, but OC gas. And there were broken glass. There were, so that part is relatively clear. But do you also have to know that a Secret Service protectee was expected that day? And how do you prove it? I mean, obviously, a lot of them knew, but how do you prove it unless somebody happened to write on their, in their Facebook, as some of them did, I'm here to lynch Vice President Pence, and so you do have some that are relatively easy, but there's others that aren't. And what Griffin's attorney actually argued at oral argument was, well, by the time Griffin got there, he got there around, I think, I forget, maybe 2:30, and he figured that because of the riot, the Secret Service would have whisked Pence off the premises by then. So he certainly didn't know Pence was still there. Is that a defense really to being in a restricted zone? So anyway, this was the question, and unfortunately, there's a lot of precedent out there that if you apply mechanically, it sounds like, well, the knowingly is at the beginning, everything afterwards got to be knowingly, and so Nina Pillard wrote a very good, I sort of commend it to you if you have patience for this sort of thing. It's a very good ruling. You can see her sort of crawling through the coils of razor wire that are that textualists precedents have created, trying to get to sanity on the other side. And she pulled Judith Rogers along with her, and as you would expect, needless to say, Gregory Katsas dissented, and Katsas is the one who dissented in Fisher.
And Katsas is a judge who, I mean, he's a very, very fine technical judge, and he commands a lot of respect among the, in general at the Supreme Court, but among the conservatives at the Supreme Court in particular. And I think you can probably expect this to be Fisher too next year.
Yeah, I think there's a very good chance we haven't heard the last of this case.
So how many cases does it affect?
At least 1,417, but at some point DOJ stopped printing those figures. So, and I would add that 171 of those, they have been enhanced to felonies because the people carried dangerous or deadly weapons at the time. So, and those would be tossed as well.
All right, we are going to go to audience questions. A reminder to those who are joining us on YouTube that you can get your I was going to say you can get your cancers answered, but I meant you can get your questions answered by joining us in the studio. Become a material supporter of Lawfare. We will share the link with you once more to do that. Andrew, the floor is yours.
Hey, everyone. Interested sort of primarily in Roger's thoughts on the strength of the government's opposition to the supplemental Trump motion to dismiss based on Fisher. I saw your tweet thread when it came out maybe last Wednesday or sometime last week, including a note about a Second Circuit case, Reich. Just wondering if you think that case is really on point, or if there's some issue because these fraudulent certificates didn't have an effect. Maybe this is just an instance of an attempt at a 1512C crime, but just wondering about your thoughts on sort of how that turned out.
Well, 1512C2 and C1, 1512C does include attempts. So that won't be, I mean, the fact that it's a mere attempt won't be a problem. And I think, as I was mentioning earlier, with all of that evidence of the efforts that went into trying to get those final Wisconsin and Michigan false elector packages to Vice President Pence, I think they can make that out. I forget the facts of Reich already. I know it was written by Sotomayor when she was a Second Circuit judge. So I don't think she'll have trouble following it. But I can't remember but I think the Trump's attack will go like this. It will be, yeah, creating false evidence might be covered, but this isn't evidence. This isn't an evidentiary hearing. This is a ministerial hearing. You said it yourself. You know, that's your whole theory, that this was ministerial and Vice President Pence didn't have the power to do anything but open envelopes. That's not an evidentiary hearing, so this can't be false evidence. I think that's the argument that they'll use. And it will not prevail with Judge Chutkan, but, you know, if it gets to the Supreme Court, you know, who knows?
All right. Lawrence asks, what does the Lawfare team make of the new Trump defamation case filed by the Central Park Five? This is a little bit beyond the scope of what we normally talk about here, but the background here is that Trump has repeatedly said over the years that the Central Park Five, he's urged the death penalty for them back at the time. And he's even after their vindication, which I believe was on DNA evidence
yes, you're right. I'm sorry.
He has continued to insist that they're guilty. They recently sued him for libel in connection with that. I am not clear. So the broad answer to your question is it almost entirely depends precisely on what he said. And so I asked Quinta while Roger was doing the overview to look up exactly what the statements at issue in this libel case are. And Quinta, what did you find?
Yeah, so it's a little hard to say, to be completely honest, because this is a comment that Trump made during the presidential debate with Kamala Harris. And as many of his answers were, it was kind of garbled. So I'm looking at the actual complaint right now. So the context is the candidates were discussing, or as the complaint describes it, a segment of the debate dedicated to race and politics in this country. Vice President Harris said, let's remember, this is referring to Trump, this is the same individual who took out a full-page ad in the New York Times calling for the execution of 5 Black and Latino boys who were innocent, the Central Park Five. Then Trump responded, I'll just read it to you. They come up with things like what she just said, going back many, many years when a lot of people, including Mayor Bloomberg, no, Bloomberg was not the mayor at the time of the Central Park Five case, agreed with me on the Central Park Five. They admitted, they said they pled guilty. And I said, well, if they pled guilty, they badly hurt a person, killed a person ultimately. And if they pled guilty, then they pled we're not guilty. I have to be honest, I don't know what that means. So obviously Bloomberg was not the mayor. The mayor at the time was Ed Koch. I don't believe that at any point the Central Park Five pleaded guilty. I'm not
I
completely
believe they
clear.
did. I believe some
No.
of them did.
No, so
They
so according, sorry, I'm looking at the complaint here. Plaintiffs never pled guilty to the Central Park
Okay.
assaults. Plaintiffs all pled not guilty and maintain their innocence. So I suppose you could say maybe Trump is getting confused and saying, oh, they pleaded guilty and then they rescinded it and pleaded not guilty. It's really not clear.
I think he's confused. There were confessions.
Okay.
And so the confessions were
I see.
were
Okay.
disputed. You know, they were kids. They had been kept up a long time, and they were underage and weren't allowed to have this and that. But they confessed. And so I think that's what he's saying. And then, yeah, eventually the guy who really did it confessed in prison, and his DNA matched.
Right.
And then it developed that they had sort of mischaracterized. They had said that the DNA evidence was inconclusive, and that wasn't really right. It was actually pretty exonerating. So anyway, but so I guess for a public speaker in that context to get wrong, pled guilty versus confessed, I doubt that's, I don't know. I haven't read the complaint. If that's really it, I don't know if that's going to be actionable.
Yeah,
I mean,
especially because he ends by saying, if they pled guilty, then they pled were not guilty.
Yeah, I just want to say it's a hell of a defense. My statement wasn't incoherent enough, though made with malice and reckless disregard for the truth. It's not coherent enough to parse and therefore can't be actionable. That would be a hell of a defense. All right, Nathan asks, if, God forbid, Trump is reelected and he follows through as promised by ordering his AG to fire Jack Smith, and by ending the prosecution Smith has brought, is there no legal protection or other recourse whatsoever Smith could take to prevent the end of these prosecutions? Could Smith have standing and make any arguments in, say, Judge Chutkan's court? All right, so I'm gonna take this one myself. So first of all, here is the entirety of the rule in the special counsel regs. It says the special counsel may be disciplined or removed from office only by the personal action of the attorney general. The attorney general may remove a special counsel for misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause, including violation of departmental policies. The attorney general shall inform the special counsel of the specific reason for his or her removal. So notice that, you would have to contrive some kind of misconduct. I give him an order, say, to dismiss the case that he refuses to follow, and then dismiss him for that. There is no provision for judicial review, and this was actually one of the issues where in the various Mueller Protection Acts that Congress was considering giving the special counsel a kind of judicial review was one of the things that then Mueller protecting Senator, I believe, Lindsey Graham wanted to do. That was a long, long time ago. So the second component of this question is, is there anything so I don't think there's a prospect for judicial review of the firing. There is prospect for judicial review of when the department goes and asks to have the case dismissed, that has to be accepted by the court. Now, I don't want to overstate this because a court would have to grant that motion, and I'm sure Judge Chutkan would have some reservations about a motion that was sort of pretty clearly corrupt in that regard. That said, as we saw in the Flynn case, at the end of the day, the courts are not going to force the Justice Department to prosecute a case that they don't want to prosecute. And in the Flynn case, it dragged on long enough that Trump just kind of nuked it by pardoning him. So I would expect there to be some friction associated in Judge Chutkan's court associated with the decision to an order to dismiss or a request to dismiss. But I do think eventually, don't kid yourself, the Justice Department is going to have its way on that one. Do either of you disagree?
I wonder if Chutkan will try to appoint a prosecutor, I don't know what you would call him.
Be like a special prosecutor.
Yeah.
You
Mhm.
sometimes
And-
see that in cases where there's like a criminal contempt, that the judge will sort of appoint somebody to prosecute it. I don't think you could do that in a case of this magnitude.
Yeah, somebody mentioned the Steve Donziger case, which was a contempt, I think. She could appoint Jack Smith. And it might go that way. But then there's a question of who's going to pay for that and all sorts of things.
All right, last question of the day. There is reporting by 12 conservative media sites, according to Straight Arrow News, that Nathan Wade testified that Fani Willis did in fact meet with White House officials. One, is it true? Two, does it matter? So the testimony, Nathan Wade testimony transcript, deposition transcript is available. It does seem to, I have not read it. I scanned it in an attempt to answer this question. It appears that he does acknowledge at a couple of points that there were contacts with the White House counsel's office and maybe also the January 6th committee. To my knowledge, that is not inconsistent with stuff that they've said in the past, which is, that there were, and maybe in Dan Kleidman and Mike Isakoff's book, that there were contacts about whether they could get information from the January 6th committee witnesses and, deposition transcripts and whatnot and exhibits. And so he does make clear that there was no sort of like coordination with or pressure from the department or the White House to bring the cases. So I am not sure it's different from anything he's said or that the office has said or acknowledged before. But I would have to go through it with a fair bit more detail than I have in order to be certain of that. So we are going to leave it there. Thank you all. We will be back next week. And we will be back next week. The Trump will, even during this election period, will continue trialing and tribulating. And we're going to be there every step of the way, ignoring the election as it looms around us, except insofar as it shows up in the cases.